Dear friends of the LPs network, my name is Jaap de Zwaan. I'm an emeritus professor of European Union law at the Erasmus University in Rotterdam and also the former director of the Netherlands Institute of International Relations, Klingendaal. It's a pleasure to be able to prepare a video for the LPs law review. Thanks to Vasco for this nice invitation. Actually, my intensive course at the law school of Universiteit Lisboa deals with asylum and immigration law and policy of the European Union. However, also in view of the available time, in this contribution, I will, under the heading of the overall topic, weakness and effectiveness in law, focus more particularly on one dimension, the asylum dimension of that global subject matter. And the title of my presentation is From the Internal Market, reference to the past, to the new Pact, which will be a full application as from July next year. However, dear friends, be aware that also again, in view of the available time, I will discuss only the main elements of the common European Union asylum system as it has been developed over time, and so not give a full-fledged overview. So let's start with some preliminary remarks. As everybody is aware, also in Portugal, the asylum problematic is a highly political sensitive policy area. It's a hot issue practically in all the member states. And in this light, I only have to refer to the political move to the right, not to say the extreme right, in several of our European Union member states. And obviously a connection is made between the assumed massive influxes of asylum seekers on the one hand and the consequences for family reunification, housing, food, clothing, education, the public, financial resources, social security, and the possible access to the labor market of asylum seekers on the other. It's a complicated issue. And second preliminary remark, the asylum problematic is a phenomenon of all times. Portugal is an example of a migration country. My own country, the Netherlands, is an example of a migration country. So over the centuries, people have moved from the one region to the other, either to find a better future or to look for protection. And in recent times, when it comes to asylum seekers, we only can refer to the Syria crisis of 2015 and 2016, and still well over 1 million of Syrians are still residing in the European Union. Certainly, since 2016, numbers have gone down, but still they are significant. And because of the Russian aggression in Ukraine, as from 24 February 2022, millions of Ukrainians have found hospitality in the member states of the European Union, and still around 4.8 million Ukrainians are residing in the European Union. Now, next question. Why so many migrants try to get protection, more particularly in Europe? Well, dear friends, no surprise. Already for quite some time, at least the western part of Europe, of our continent, is a stable and peaceful place. So since tensions, war, conflicts are taking place in our direct or indirect neighborhood, Middle East, Africa, and so on, Asia, and because of the reputation of Western Europe as a safe area, one can expect that situations of migration will continue also in the future. And that means that asylum is a problematic which will not disappear from our European agenda from one day to the other. Next point, why it is the European Union that deals with the asylum issues and not the individual member states themselves. Well, it's not so much because the European Union represents a collective of member states, these days 27 in total. It's rather because the European Union has developed itself into a single economic and human space. The human space refers to an area governed by the well-known fundamental values, human rights, democracy, the rule of law. An economic single area refers to the creation earlier on, the main objective of European Union cooperation related to the establishment of an internal market, the area without internal frontiers in which free movement of goods, persons, services, and capital is ensured. And it is for obvious reasons that once you create a free area without internal obstacles, you have to provide for an external dimension, also with regard to movement of persons, in this case, more particularly third country nationals coming to the European Union, visa policy, legal migration, tourists, students, researchers, what have you, and finally, but not least, also asylum. Is an area to be covered by the external dimension of movement of persons. So that means that we can already draw an important conclusion. Asylum reflects a common problem for the member states and has to be solved commonly. I hope you do agree with that point. Now, what do we have achieved so far? And actually, it is quite a lot. So, of course, the European Union respects the provisions of the Convention of Geneva of 1951 and the Protocol of New York 67, of course, 1967. And certainly, more particularly, here the reference to the droit de refoulement is of importance. So the prohibition to deport any person to a country in which their life or freedom would be threatened. So that's the basic issue of the Convention of Geneva. And also in our own European Union Charter of Fundamental Rights, there is an Article 18 reflecting the right to ask for asylum. Now, when it comes to the substantive legal instrument of the European Union, it is important to note that I always call them a first generation of legal texts. They date back to before the Syrian crisis. Most important instruments date from 2012 and 2013. I mentioned the following concepts and principles. The qualification, certainly. We had to agree, which was not that difficult, by the way, about the definition of refugees. The third country national who fears being persecuted for reasons of race, religion, nationality, political opinion, or membership of a particular social group. We have added in the European Union, under the heading of qualification, the category of beneficiaries of subsidiary protection, which category was introduced in light of the experience we gained during these horrible civil wars taking place in the 90s in former Yugoslavia. There is a second important point, the responsible member states. So the question has to be answered once a third country national presents him or herself at the external border, who is the responsible member state to examine the relevance of such a request for protection. Now, in the text dating back to 2012, a hierarchy of criteria has been developed. The variation is in a minor, unaccompanied, or do family connections do exist in a certain member state? Has an earlier permit already been granted? And can you refer to an earlier stay of the person involved in one of the member states? In that case, the reference is to the other member state. However, generally speaking, the final result is that the member state of first entry is the responsible member state. It goes by itself. Procedures. We had to provide for fair and human procedural arrangements, including deadlines, possibility for legal assistance, interpretation, and possibilities for appeal in case of a dismissal of a request for protection. Reception arrangement, obviously also important. Housing, food, education for minors, and also in the end the question, can you give access to the labor market of your member state for an asylum seeker? And finally, a database. So Eurodac, that's a computer system which collects information of asylum seekers. And actually, in this group of fundamental legal instruments, also the reference has to be made to the directive related to displaced persons. Displaced persons refers to people who have had to leave their country or region of origin or have been evacuated and are unable to return in safe and durable conditions because of the situation in that country. The origin of this directive, which dates, by the way, back to 2001, was again the crisis, the civil wars taking place in former Yugoslavia in the 90s. However, for the first time, this directive of 2001 has been applied in 22 in order to cover the situations of the Ukrainians, the millions of Ukrainians fleeing to the European Union after the Russian invasion on 24 February 22. Now, what can we learn from the experience in practice of these instruments? There were three main points I want to mention. The control of the external borders was difficult, more particularly in view of all the migrants coming from Asia, Syria, but not only from Syria and Africa. They had to cross the Mediterranean, and especially there we have witnessed difficulties and dramas encountered at sea, and those things hinted at the fact that our system was not clearly perfect. There is also the principle of member state of first entry, so the responsible member state gave rise in the practice to a situation of overloading the authorities on the Greek islands and the Italian island of Lampedusa. So since the member state of first entry became in practice the general principle, the general rule, we have witnessed these awful situations taking place on certain islands in the Mediterranean. And then certainly, and that's a very sticking point, the return, how do you return illegal migrants? So those migrants whose application has been dismissed and who are clearly having no right to stay further on in the European Union. So actually the score in that area was one out of 5, so 20% people of the total number of illegal migrants. And that, of course, gave rise for objections and saying, how can we improve that situation? Now, the second generation of legal instrument has been introduced by proposals the Commission has made on the 23rd of September and 2020, a complete set of new proposals in order also to provide for remedies for the weaknesses I discussed earlier on. And that was politically a difficult exercise. So as I mentioned, the proposals date from September 22. However, a final political decision-making dates back only to February 24. And the publications of the official text, quite a number of regulations and one directive, by the way, 9 regulations and one directive, they date back to May 2024. Now, to make a long story short, the Commission departed from their assumption that most migrants arriving in the European Union do not have a right to stay. in the European Union. So they provided for an innovation, and more particularly I want to refer here to the introduction of a quick scan proceeding at borders, officially referred to as the border procedure. It's focusing applicants of a nationality for which the proportion of positive decision is 20% or lower. Also, an applicant misleading the authorities of presenting a danger for national security. So those people, but of course mostly important is the category of applicants of a nationality for which the proportion of positive decision is 20% or lower, they are referred immediately to the return procedure. Then, and that's also very important as to substance, the Commission introduced a new kind of principle, flexible solidarity. The principle according to which overloaded member states, which are responsible for the examination of applications for international protection, may ask for assistance by other member states. So the Greeks and the Italians, later on the Spanish and the Cypriot authority, will be in a position to ask to invoke assistance of other member states. And the Commission has provided for three categories of member states who you can address. Member states under pressure, again, Italy, Greece, but also Spain and Cyprus. A number of member states at risk of a migration pressure, and member states facing a significant migratory situation. Depending on where the member states concerned fits in, then you have to provide for contributions to deliver to the member states overloaded by applications for asylum. Either you can choose the relocation, and relocation means the transfer of a person from a country, in principle, the responsible member state, to another member state. So from the south to the north or to the west or to the east. The second point is you can pay for a certain financial contribution, 20,000 euro per migrant, and or you can provide and offer alternative solidarity measures, for example, making available staff, material, or technical in-kind support. But mind, the system is mandatory, but you have the option to choose, but you have to do something. And also with regard to cooperation with third countries, the idea has come up to conclude more full-fledged comprehensive partnerships, focus more particularly on the element of readmission, and also try to combat smuggling, for example. Now, certainly those new elements will most obviously have their value when this whole set of regulations and one directive is put in place. Finally, July 26, so we are in the preparatory stage. However, there's also this one sticking point, how to return illegal migrants, because this is a process, it's not by itself. As I mentioned, 20% of illegal migrants not having the right to stay in the European Union, we are able to return and readmitted in their country of origin. And that is something which is, of course, direct to the heart of politicians, which became very impatient, have said, okay, this is wonderfully well, but we have to provide for new modalities enabling us to return migrants, illegal migrants, perhaps not only to their country of origin, but also to the neighborhood, to the extent the neighborhood is safe. And in order to cover those remaining problems, the Commission has come forward, and that's an interesting aspect, that all these elements are dating back to this year. In March and April and May of this year, the Commission has come up with three full-fledged proposals dealing with how to return an illegal migrant to a safe third country. What do you mean by a safe third country? And let's try to make clear and to make explicit what could be a first list of European Union or of safe third countries as they are considered by the European Union. So, and the idea has also been not only to focus on returning of illegal migrants to safe third countries, whether the country of origin or another country in the neighborhood, for example, but also to involve those countries as countries of transit, for example, in the process to examine applications for international protection. There are three issues I want to mention. The idea of a return hub. And the return hub has been proposed by the European Commission in the context of a new common system for returning illegal migrants. The reference is here to the conclusion bilaterally by member state or by the European Union itself of an agreement with third countries. However, it should always be a country respecting international standards and human rights. That's an important condition, by the way. So a return up, which you might designate collectively at EU level or individually by member states. Then the Commission has come forward with this idea of safe third countries and a first list. Again, the focus is on third countries with a 20% or less recognition rate threshold. So that's, of course, in the area we should consider collectively these countries where asylum seekers have hardly a chance of success in the EU to connect them to our network, how to return illegal migrants to a safe third country. More importantly, however, is the fact that the European Commission has made explicit a first list of third countries to be considered safe. It's a very tiny, small list. That's one of the problems. Kosovo, Bangladesh, Colombia, Egypt, India, Morocco, and Tunisia. And the reference is also to candidate member states of the European Union for obvious reasons. However, the addition is in principle because you never know what happens in one of the candidate member states before they are becoming full-fledged member states. Could be political developments taking place, affecting the fundamental values, human rights, and what have you. The third element is more particularly important, I think. That's the proposal the Commission has put forward in May of this year about how to interpret the notion of a safe third country. And that's particularly important because whereas up to now, we have to demonstrate in order to return a illegal migrant to a safe third country that there is a connection between the applicant and that third country. Commission is now of the opinion that that is no longer necessary. Actually, transit of the migrants through a safe third country can also be considered as a sufficient link. And then there is another one. If there is no connection between the applicant and the safe country or a transit country, the option has been foreseen of an agreement, this time concluded by the member states, with a particular safe third country. So that goes rather far, isn't it? And the condition before putting in place and having this arrangement in the process of application, the Commission has to inform, or no, the member states, the member state who concludes this arrangement has to inform the Commission before concluding the arrangement. Now, funny enough, there was such a pressure on these proposal that relatively soon, because the proposal dates from March, April, and May, actually in the beginning of December, the 8th of December, under the Danish presidency, all these questions and all these delicate issues about reference to what is a safe third country, a political agreement has been reached. So at the level of the ministers, Justice and Home Affairs. However, that is not the end of the procedure. These political texts still have to be discussed with the European Parliament because it's all subject of co-legislation between the Council and the European Parliament. Now, by way of conclusion, and of course there is a lot more to say about this, I like to mention the following. Asylum is a problematic of all times. Europe is one, let's be happy with that qualification, of the rare areas in the world where peace and stability have been achieved. Now, since war and unrest are taking place everywhere around us in the neighborhood, Eastern Europe, the Middle East, Africa, Asia, we in Western Europe are actually confronted, let's accept that fact, with a problematic that is hardly to solve in an effective manner. And as discussed, the new Pact on Asylum and Migration has certainly brought improvements, and it will be of application in July 26, full application. And however, the way all these new principles have been elaborated, such as flexible solidarity, it looks rather technical and bureaucratic. So the effectiveness of these principles in the practice depend largely on the way they will be applied by the individual member states themselves. And here the reference is to solidarity, burden sharing, and responsibility. However, there is the second point, and that is the effectiveness, but then also referring to cooperation by third countries. So here the effectiveness of the whole set of rules will also depend on the cooperation to be delivered by safe third countries. However, with regard to the examination of requests for protection and the return of illegal migrants by third countries, considered to be safe, especially the arrangements regarding the implementation of that particular concept, what is a safe third country, may in practice easily give rise to contestations in court. So it was nice to speak to you. The discussion will be continued. You can be sure about that. And I thank you wholeheartedly for your attention. Bye-bye from the Netherlands.